attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a Lawcast series talking about the SEC's Division of Corporation Finance's disclosure review and comment process. Back in March 2016, I wrote a blog and did a Lawcast series on the SEC's Division of Corporation Finance's internal review process, review levels, and breakup of industry sector reviewers. I'm going to refer as the Division of Corporation Finance as CorpFin. On March 22, 2018, CorpFin updated its Filing Review Process page on the SEC website. At the end of each calendar year, the Big Four accounting firms generally publish studies on CorpFin's comment priorities. Their studies and other recent publications uniformly found that the number of comments, especially in a registration process, has dramatically declined. I have noticed this trend as well in my practice. Also consistent in numerous reports is the list of recent comment priorities, which includes non-GAAP financial measures, the application of the new revenue recognition standards, disclosure of cyber risks and cyber incidents, management discussion and analysis presentation and disclosures, including segment reporting and income taxes, the disclosure of intangible assets and goodwill, state sponsors of terrorism, disclosures related to acquisitions, mergers, and business combinations, and the signatures, exhibits, and agreements section. This past year, in September 2017, the SEC Office of Inspector General published an evaluation of the Division of Corporation Finance's disclosure review and comment letter process, which I'm going to refer to as the September 2017 report. The purpose of the Inspector General's examination in the 2017 report was to review CorpFin's process for issuing, tracking, and facilitating public access to comment letters and related correspondence. In addition to summarizing the September 2017 report, this Lawcast series includes information on the updated CorpFin Filing Review Process page and general commentary and information about the process. CorpFin reviews and comments upon filings made under the Securities Act of 1933 and the Securities Exchange Act of 1934. The purpose of a review by CorpFin is to ensure compliance with the disclosure requirements under the federal securities laws, including Regulation SK and Regulation SX, and the general anti-fraud provisions, which require disclosure of material information necessary to make the required disclosures not misleading. The standard for required disclosure is generally the materiality of the information. In TSC Industries versus Northway, Inc., the U.S. Supreme Court defined materiality as information that would have a substantial likelihood of being viewed by a reasonable investor as having significantly altered the total mix of information available. CorpFin selectively reviews filings, although generally all first-time filings, such as a first-time S-1 for initial public offering or first-time Form 10 registration statement under the Exchange Act, are fully reviewed. The Sarbanes-Oxley Act of 2002 requires that CorpFin review all public companies at least once every 3 years. Section 408 of the Sarbanes-Oxley Act requires CorpFin to focus on companies that have the largest market capitalization. Section 508 of the Sarbanes-Oxley Act specifies certain factors that the SEC should review and consider when scheduling reviews, including market capitalization, financial restatements, volatility of the company's stock, and the price-earnings ratio. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.